The most serious domestic violence charge in South Carolina is domestic violence of a high and aggravated nature, and it carries a penalty of up to 20 years in prison if convicted. This charge requires harm or the threat of harm to a household member and the addition of at least one of 3 aggravating factors. We're going to discuss those factors today. Hi, my name is Dale Savage and I'm a criminal defense attorney here in Charleston, South Carolina. And today we're talking about domestic violence of a high and aggravated nature. So why is this charge the most serious domestic violence charge in this state? It's because to get to this level, you must have committed either domestic violence in the first, second, or third degree, and then an additional act known as an aggravating factor. There are 3 aggravating factors that can elevate your domestic violence first, second, or third degree charge to domestic violence of a high and aggravated nature. The first aggravating factor is when the accused commits the offense under circumstances manifesting extreme indifference to the value of human life and the victim suffers great bodily injury. The second aggravating factor is when the accused commits the offense under circumstances manifesting extreme indifference to the value of human life, with or without injury, but the victim reasonably feared great bodily injury or death. The third aggravating factor is when you violated an order of protection and committed domestic violence in the first degree. So what does extreme indifference to the value of human life mean? It can be defined as using a deadly weapon, choking the alleged victim, causing loss of consciousness or near loss of consciousness, committing domestic violence in front of a minor, committing domestic violence against a pregnant person, committing domestic violence during a robbery, burglary, kidnapping, or theft, or preventing the alleged victim from calling the police or EMS. The difficult cases are not the ones where the facts and evidence clearly show a victim who has suffered great bodily injury, but rather those cases where the accusation is that a weapon was used or that they were choked and there is very little to no physical evidence to support that claim. What makes these particular cases difficult is they lack independent evidence to corroborate the claim. When there is little to no sign of physical injury, or in the case of a deadly weapon, there are no physical signs of a weapon being used, it comes down to being a swearing contest between 2 people. Often, these cases will result in a jury trial to determine who to believe. And if you're the accused, that means you must make the monumental decision of whether to testify or exercise your right to remain silent. That's an incredibly difficult decision to have to make, and if you have a prior criminal history, you could open the door to all that coming in trial if you're not careful on the witness stand. So it's important that if you are in this position, that you carefully discuss your decision and which way is the best way for you to go with your attorney. If you've been charged with domestic violence of a high and aggravated nature and want to discuss your case, please give me a call at 843-530-7813. I hope this video was helpful, and thanks for watching.